Okay, so we talked about closing arguments a little bit. The closing arguments is when the attorneys are summarizing their case to the juries, and they're trying to organize it so the jury can understand, you know, the case, argue the practicalities of the case, and they can take any kind of reference that they want. They can use the Bible, they can use movies, they can use popular sorts of things to try and get the jury to understand, and they do that as well. So it's very interesting to see, because so the prosecution goes first, and they use all these summary techniques, and then the defense goes, and then the prosecution is given the time to, if they want, rebut anything that the defense says in their closing argument. So from a cognitive psych perspective, the prosecution has the advantage both with the primacy effect and the recency effect. So what they hear first might stick, and then also what they hear last might stick. So a smart prosecutor would take advantage of that rebuttal and do both the primacy and the recency effect to make things stick. So we talked a little bit last time in class about the judge's instructions and how the judge has to give instructions first. And it would be easier if they gave, last, after the end of all the evidence, it would be better if they gave pre-trial instructions, because it's easier cognitively for the jurors to understand. And so that's, and that, it would also be easier to give layman's instructions. Even with layman's instructions or reform instruction, so we had pattern instructions, which are the traditional legal instructions, and then reform, which is written in layman's terms. But even with the layman's term, the jurors still confused very basic concepts like aggravating and mitigating circumstance. They totally didn't understand those things. So you see some difficulty not only with aggravating and mitigating circumstances, but with other types of instructions. So cautionary instructions, which are the type of instructions that informs the jurors to be careful about how they interpret the law. Remember that it's this and not that, and remember that you're supposed to apply the law in this particular way. Jurors also are given cautionary instructions, and they also confuse those at times. Judges also give admonitions, and admonitions are like finger wagging. Remember, that was stricken from the record, and you're not to use that in deliberations. So they admonish or give the jury a little lecture to not pay attention to things, or to pay attention to something. It's meant to limit what the jury can and cannot do in terms of certain types of evidence. But those things backfire, because when they give an admonition, they're actually making that forbidden fruit sort of thing, and the jury is more apt to use that sort of thing. A lot of research has been done about what do jurors understand, and they use linguistics, because a lot of the legal terms are very different and odd and Latin-based, and people have a hard time understanding those things. And then, of course, they have a hard time understanding it, they're going to have a hard time applying it. So that makes things really difficult for them to do and do a good job with deliberation and defining different legal terms and things like that, because you could be in a jury situation and your definition of something as you understand it, without the judge helping you at all, is going to be different than someone else's. And so whose definition do you listen to? There's also the thing about written instructions and even trial transcripts being available to the juries, and that does vary by state and vary by locale. And even if written copies, they still influence the jury's decision in different ways. And jurors who had written instructions didn't argue so much about the legal issues, but they looked at more of what did the judge say. So that changes their focus on what they were there for to begin with. So in a way, it kind of interferes with what they were going to do. The idea of giving pre-evidence instructions is that it helps the juror understand how to construct the evidence, okay? And usually, it helps them understand and make a construction, make a coherent whole. We talked a little bit last time about the story model and the meter model of how evidence is processed. So researchers think that there's two basic types of evidence processing for cognitive psychology applied to how they make their deliberations and how they do their decisions. And one is that they do a verdict-driven sort of composition where, okay, it's guilty or not guilty. I'm looking at the guy, I think he's guilty. And then they interpret the evidence as it comes in, bearing in mind that I think he's guilty, so now I'm going to listen to all the evidence that fits that guilty sort of verdict. That's a verdict-driven, and it could work the other way, not guilty. And then there's evidentiary-driven. So evidentiary-driven is the way it's supposed to be, like you hear all the evidence, and you're weighing it one way or the other. I'm like, this is strong evidence, so I'm going to put this in the strong evidence, and that's weaker, I'm going to put this in the weaker. And then at the end you have a balance of which you decide. So you would hope that everybody uses evidentiary type cognitive style, but in reality, most people do verdict-driven decision making, and then it gets worse when it gets into the group, because then the group and deliberation, there's pressures from a group to reach a particular decision, and we're going to talk about how the jury reaches those decisions. So it is especially true for evidence and organization, and what they're using the story model, the meta model. How are they cognitively assembling the job of assembling the evidence and make it coherent and interesting? So there's a lot of different things that could happen there, a lot of different interpretations on how a juror comes to assemble that evidence, okay? So pre-instruction is very important. The other thing about pre-instruction things that they found was that if this is my research partner in Australia, her name is Lynn Fosterly, and you'll see in the chapter, she's mentioned in the chapter, but she did her work on, I'm going to put some instructions in from some evidence in from the case, and it's going to be not true, completely not true. And she called those not true pieces lures. Okay, they lure the juror to use it in their decision making. So she had the hypothesis that if a judge gave pre-instructions, okay, pre-trial instructions versus post-trial instruction, how would that affect when something was patently false? And ironically, what she found was that if the judge gave pre-trial instructions and she put lures in, things that were false, the jurors were much better able to say, wait a minute, that's not right. So they were able to detect a false piece of evidence when it was there, if the evidentiary instructions were given before the presentation of evidence. For the post-evidentiary instructions, so they hear the whole trial, and then the judge gives the instructions, they were much less able to identify a piece of information that was false. So there's some statistical evidence, the lore study we called it, for people to get pre-evidentiary instructions, okay? The thing I didn't mention at the story model is if the person who's doing the story model and they're using an evidentiary cognitive decision style, where they're listening to the evidence and they're weighing where it's going to be, versus someone who's verdict-driven. So if you're doing a verdict-driven and you say, I think this guy is guilty, and you're only listening to those pieces of evidence that fit that category that you have in your mind, that bias, that person is guilty. So I have this. Oh yeah, they said that, but I'm going to just not pay attention to that because I think he's guilty. What happens is, if you have a scenario where you're constructing that, and there are some gaps in that scenario, research has found that jurors will fill in those gaps with their own thoughts, their own emotions, their own personal interpretations versus different pieces of evidence. So that's a weakness, another weakness of the verdict-driven response, okay? Also, there are individual differences between people. Don't think that all jurors are the same. People bring their baggage into court when they sit on a jury. And different personalities come to different conclusions. But the one that they really have talked about a lot in research is someone with an authoritarian personality. And an authoritarian personality is a type of person who sees things in black and white. They have an allegiance or a susceptibility to believing what an authority figure says. They want simplistic bottom line answers. They don't want to give a lot of cognitive energy into solving a particular problem. They aren't overly influenced by a judge and a judge's instructions, and they are more conviction prone. So the authoritarian personality, if you have a couple of those on the jury, it's more likely, statistically more likely, to result in conviction versus if you didn't have an authoritarian on the jury. So authoritarian levels within a personality also does affect the jury. So having someone that is more conviction prone can lead to more convictions. There's also legal authoritarianism, which favors the prosecution and not the defense. And so legal authoritarians deal with the individual's attitude about the trial and about the legal system. They're the ones that likely come into a courtroom and go, hey, you know what, they're charged with it, they must have done something. So then they look for evidence that supports that whole guilt thing because they are more conviction prone to begin with. So authoritarianism in general, and also legal authoritarianism will also affect the case. Then we have different types of people on the jury that we call satisficing. A satisficer bases their conclusion on minimal amount of evidence, okay? And they draw their conclusions. They once they come up with their conclusion, they stop hearing evidence. They're satisfied. They're called satisficers. And then once they've made up their mind, they will try and persuade all the other jurors to see things in their way, okay? And they don't like attitudes or pieces of evidence that contradict what they're saying. So satisficers are minimalists, minimal effort into a decision, and they're going to try and convince everyone else how to do it as well. The most effective type of reasoning is the theory of evidence coordination model, which looks at the construction of two or more stories to be evaluated against each other. So they are very much the opposite of satisficers. These folks will weigh in evidence and they're constructing stories and they say, do we believe it happened this way or do we believe it happened this way? Sometimes they have two, sometimes they have three, they have four possible things that could have happened in the scenario, and they're entertaining all of those at once. So that's a different type of thing that's happening internally as well. So on the next video, I'm going to talk about the dynamics of the jury in terms of composition and decision roles and things like that. So that will be the next part. Okay, let's stop this here.